All right, welcome everybody. This is the public hearing of objections meetings for Amendment Z22-09 to the zoning bylaw, which is Z22-01 for the town of St. Andrews. Here we are on St. Patrick's Day, Monday, March 17th at 6:30 p.m. at the W.C. O'Neill Arena Complex Chambers. This meeting is being streamed through Zoom and Facebook. If you have any opposition to anything this evening or something in support for this particular hearing of objections, we will do a call through Zoom here momentarily. But at any time, you can also submit your feedback to council, although there is a motion coming up in the regular meeting. Let's get into the recording of attendance. I see that all members of council are here. Is Councillor Blanchard online or no? Okay, so everybody except Councillor Blanchard. Thank you, Councillor Hurl, for joining us virtually. And I do want to recognize that we are on the unceded traditional territory of the Peskotomuhkati people. Approval of the agenda. Could I have someone move? It is just the one item, the hearing of objections for this first meeting. I've got Councillor Gumashell and seconded by Councillor Heenan. Any discussion on the one item? Seeing none, all in favor of approving this agenda, please signify by saying aye. That's everybody. Agenda has been approved. Any conflict of interest? Seeing none, there is no presentation, so let's just get right into the purpose of the meeting, which is the hearing of objections. Once again, it is amendment number Z22-09 to the zoning bylaw Z22-01 for the Algonquin Spa public hearing of objections, which is PCD 250206. Would anyone in the audience this evening wish to speak in regards to this particular hearing of objections? I'll call one more time. Would anyone in the audience this evening like to speak regarding this hearing of objections? Okay, I note that no one in the audience would like to speak. Is there anyone online?
Through your worship, there is online, but they're the representatives of the Algonquin, so
okay.
I doubt they'll have any further comment than what's been provided.
All right.
And I'll also note we've received no correspondence written, but I will toss it over to Mr. Alex Henderson as he has some information regarding the O'Brien House.
Thank you.
All right. Yeah, so we have some information about the O'Brien residence. This was brought to our attention just last week here. Our development officer was doing their preliminary plans review for the building permit application, and they noted that one of the apartments that was proposed has a mechanical room in it, and the bedroom is being added to the next door suite. So instead of 2 one-bedrooms, imagine a 2-bedroom and now a mechanical suite. So this changes the overall calculation that was in the draft resolution before you tonight. So instead of 20 units, that would actually be 19. So this hasn't been part of the public hearing notice, but it's staff's opinion that that is not representing a substantial change for a couple of reasons. Unlike the spa where you're changing the footprint from 2 stories to 1 story, and that substantially changes the overall gross floor area, and there's external changes to the design of the spa building, those are substantial changes which require this public hearing and review from the public. This is a sort of a change of the interior and the use of the space. It doesn't change the number of bedrooms in the overall development, so the amount of people that would be accommodated in the employee housing would be the same. So yeah, it's staff's opinion that you could proceed with tonight's resolution with a minor change to clause 14 on from where it says 20 units to add 19 units or up to 20 units as an additional way to amend that clause. In doing so, you would allow the project to continue as is and on schedule. You could also call for another public hearing to deal with this matter. But again, it is staff's opinion that you're within the meaning and intent of the act to proceed with that minor change if you so choose. We've had opinions on what's constitute a non-substantial change to a bylaw that's done at 3rd reading after the public hearing, and this is well within the scope of what you can do. So with that, I'll turn it back to you, Your Worship.
Thank you very much, Mr. Henderson. I think unless council feels differently, I do think that that's well I wouldn't consider it a substantial change by any means unless you're the developer themselves and the applicant is aware of the change, obviously, and still good to proceed with the project.
This was actually the applicant's engineer who proposed it. The original rezoning, the conceptuals, didn't actually have a mechanical room, and it was one of these things that was realized when they went set out to do the building permit plans, which are far more detailed than your rezoning conceptual drawings. So this is one of these things where it's like, oh shoot, we need to add a mechanical room in, and that required them to change some walls and ultimately change the total number.
Perfect. Thank you very much, Mr. Henderson. I'm not seeing anything from council. I think that's not a substantial change by any means. It'd be different if you're going from 20 to 30 units, for example. That'd be a substantial change. All right, Councillor Heenan.
Yes, Your Worship, I would just like to thank Mr. Henderson for bringing this forward to our attention. Thank you very much.
Thank you very much, even though he's not wearing green. That's what happened to me all morning, so now you know how it feels. Moving on. So we've asked the public, and we've also did call online. All communication, which to the changes has been none, has been submitted to council previously. So council, with that being said, we will go to adjournment. Could I have a motion to adjourn at 6:38 p.m.? I've got Councillor Heenan, seconded by Councillor Neal. All in favor of adjourning, please signify by saying aye. That's everybody. That hearing of objections has been adjourned.